and welcome to a newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape.
Restrictive covenants have a habit of resurfacing decades later just when somebody wants to build something new. What happens when the world around the land has completely changed? In today's episode, we're looking at an interesting upper tribunal decision involving a farm in Surrey, a barn development, and a restrictive covenant that ultimately couldn't survive. The case is Duncan Grossart and Vicky Ames, and it's a useful reminder that restrictive covenants are not untouchable. We'll look at when a covenant can become obsolete, how the tribunal approaches Section 84 applications, why the existence of a nearby 132 home scheme ended up being hugely significant. So, whether you're a developer, landowner, local authority or property lawyer, this is a really useful insight into how historic land restrictions can start to unravel when the character of an area changes.
Hello, Richard.
Hello again, Lizzie.
Hello. We are back for another newsflash episode. As you've just said offline to me, we're getting all of the post-Easter catch-up now. So this one's from the 21st of April, and the case is called speculation as to how to pronounce this, but this is our best attempt, which is Duncan Grossart and Vicky Ames, and it's from the Lands Chamber of the Upper Tribunal. It's all about discharging and modifying restrictive covenants under Section 84 of the Law of Property Act 1925. So, yeah, do you want to start off with this one, giving us some background?
Yeah, I think it should be Grossart. I think a nice kind of French pronunciation myself.
Yeah, it's got more
but I really don't know. We don't have to mention him again. But originally it was a farm. I mean, it involved a farm in Haslemere in Surrey, if you know Haslemere. Do you?
Not really, no.
No.
I was just being supportive by nodding.
Oh, right, just nodding. Well, the people can't see it on the podcast anyway. But it's concerned a barn in the farm. The farm itself had been sold off in 1996, and a local developer, I think they're in Dorking, Martin Grant Homes Limited, unsuccessfully applied for planning permission on this farm in 1996 for 300 residential units, but they failed. But they transferred 3 barns, barn conversions basically, and the original farmhouse was retained by the original owners. It was a Grade 2 listed 18th century farmhouse with grounds. But the 3 barn conversions were sold off. One was to an individual. There's a lot of changing of names and changing of sales and purchases in this case, which I'll try and cut down on. But one of the properties was sold, Sturt Farm Barn, which eventually got into the hands of potential developers. And the other 2 were sold to the same person, the Stevensons, or Mr. and Mrs. Stevenson. They had covenants in them, restrictive covenants, that you couldn't use other than as a private dwelling in one residential occupation. And this would be binding on the current sort of people subject to the covenants and their successors. And so all the 3 barns had those, together with they were allowed to build a garage and outbuildings as well. What then happened is that, the then owners of the farm had the benefit of this, and in 2003, in October 2003, Mrs. Ames purchased the farm, and with that the benefit of the covenants. What had happened subsequently, I say there was a series of sales of the property. When Ames purchased the farm, the seller, the farmhouse I should say, the seller had a Mr. Weibo. They have names I cannot pronounce in this case, Weibo, but they retained the access way. So she bought the farmhouse with the benefit of the covenants, and he retained the access way. In 2015, the then owners of the farmland got planning permission. It was originally for 135 residential units. It was eventually varied to 132. This was from the local authority, which is Waverley Borough Council. They had problems with access and had to sort of negotiate with Mrs. Barnes. And Mrs. Barnes, amongst other things, agreed to release the restrictive covenants against single private dwelling for 2 of the barns, but not for the third, for Sturt Farm barn. That wasn't up for negotiation, but she agreed to release it, the covenants and the benefit of the covenants, in favour of if she was given £45,000, or alternatively, whichever she wished, a bit of extra land and a new garage for herself. We got planning permission in 2015, and then built. Finally, I think they varied the planning permission, 132 houses in 2021, somewhere called Grasslands Close. And at a later stage, basically Grosser wants to discharge the covenants on Sturt Farm barn against single private dwelling. They wanted to build 6 houses, additional houses on this land that was the barn. Eventually, they failed in the planning permission for that, but eventually they got planning permission for 5 houses, subject to things like landscaping, so they would not be seen fully from the farmhouse. But Mrs. Ames objects to this. They make an application under Section 84 of the Law of Property Act to get the covenants modified or discharged, and she objects. I don't think it did her many favours that she'd already agreed in return for money to discharge, or at least I should say, the covenants in relation to the other 2 barns.
Can you just remind us what Section 84 actually says and what the objections were?
Yeah, there's lots of cases on Section 84. There's basically, if it's a covenant against use, a restrictive covenant, or against building, Section 84 allows 4 different grounds in which you can basically apply to modify or discharge the covenants. 3 of them were argued in this case. Firstly, Section 84(1)(a), that the covenants are obsolete, and they wanted the covenants discharged because they were obsolete. And it was held basically that they were obsolete. The refusal of planning permission for 300 houses originally was 29 years previously. There's 132 houses nearby. It's not some rural idyll. It's next to a housing estate on the edge of Hazelmere. They actually decided the covenants should be discharged in that circumstance and not just modified. But also Section 84(1)(aa), which you read in conjunction with Section 84(1)(a), which is basically where the covenants impede reasonable use of the land, and they serve no practical benefit of substantial value or advantage in a contrary to public interest. She tried to argue things like she was on low land and housing nearby, more housing would cause flooding, and she tried to argue that there'd be additional people driving down this access road, and when the 132 houses had been built, the noise of the lorries had caused structural damage to an 18th century farmhouse. She failed on that. The amount of having 5 additional houses, the additional traffic was nothing in comparison with the 132 houses in the estate. And condition of the planning permission is you have to build in water attenuation systems and the likes, to stop flooding. Doesn't always work, but so that didn't succeed. She wanted to modify the covenants there. And the third one is 84(1)(c). You're also supposed to take into account for 84(1)(aa) things like the development plan and any declared or ascertainable pattern of granting or refusing planning permission, and whether compensation would sort of adequately cover her claim, if likes the discharge of the covenants would be satisfied. And C is that there's no injury, and they decided that there was no injury to her. And the covenants were discharged, and she got 0 compensation.
There you go.
Yeah.
So what's the conclusion on this one?
Well, it's a good reminder. There's so many cases. They didn't actually quote any cases in the report, but when they had site inspections and the likes, and to see what would happen to the view and so on. I don't think she did herself any favours by accepting sort of the offer of money to discharge the covenants on the other 2 barns. But it's a good reminder that they were told there's a shortage of housing, especially in places like Hazelmere. And, if you bide your time and you're sensible about it, the covenants, you might just be able to discharge the covenants and make a lot of money for yourself. Little tips. I remember this case in 2022. We didn't actually do a podcast on it. It's called Sutton and Baines in Derby, where they wanted the covenants against anything other than a single dwelling discharged completely, which would allow anything that you can get planning permission for. In the court, basically, or the tribunal, I should say, basically decided you were being too greedy. You should have just had the covenants modified. You can build two, other than two dwellings. And also, you have to be sensible in like the way you sort of negotiate and like. Another case we did was, do you remember Foss Urban Projects in White in 2023?
Oh, I'm not sure I can remember that far back.
It was following on from Alexander Devine Housing Solutions which was the first ever Supreme Court case on Section 84, where you just ignore any correspondence and ignore the complaints of the neighbours and build anyway. And then applied to have the covenants discharged under Section 84, and they built the house already. They were actually living in this house they built in Wyndham in Norfolk. And the court decided refused to discharge the covenants because of your behaviour. So that's another thing to take into account, but it's yet another case on discharging restrictive covenants. I think it was useful as well that the covenants were, the original sort of covenants were from 1996, and the original planning applications refusing 300 houses had failed in 1996. But it's a good illustration.
Well, there we go. Thank you very much, Richard.
My pleasure as usual, Lizzie, and here we are.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.